motions that were filed by Mr. Chavez are they're not all labeled motions, but the filings that were filed were a verified affidavit, verified motion to dismiss with prejudice, a notice of special appearance, an affidavit, a fee waiver demand, an affidavit of indigency. There was a lawful demand for continuance, an affidavit of good cause, an exhibit list, a motion to admit exhibits into evidence, and a certificate of service. There was also a general memorandum of law that was filed.
Yes, and I see that. I guess all of those were filed on August 14th. Obviously 12 days ago. I guess I would just ask the defense to clarify what they're wanting to locate here today, specifically.
Sure. I think that would help us determine how to proceed. There was also a supplemental affidavit of a constitutional violation, essentially challenging the stop, which I think could be interpreted as a motion to suppress. Okay. All right. So several motions have been filed. Again, we do need to determine how to proceed today. Mr. Chavez, I did also see a motion to continue in these filings, but the way I interpreted that motion to continue was that you were requesting that the court accept your motions because they were filed outside the 14-day deadline.
It was, no, if I may.
Yes.
It was to cure. I'm in the process of moving and a lot of personal things. I was trying to meet your the required timeline that you gave me, in good faith. That was why I requested that. And again, that was more or less the reason why I requested a continuance, just to make sure that everything was filed. You had enough time to view the material.
All right. Well, I think I interpreted it correctly then.
I would.
The motions were obviously accepted by the court. Usually the remedy if a party files motions late, especially when we're in the pretrial process, a trial has not been scheduled in this matter yet. So from a procedural standpoint, the remedy would be if for some reason, if the prosecution needed more time to respond to those motions, the remedy would be continuing the motions hearing to allow more time for a response from the other side. So that's really with respect to the late filing of the motions are certainly accepted, but that's why I asked today whether the prosecution was prepared to go forward to address those motions today.
I think if we can, so my understanding, I guess, at the moment is this is essentially a reasonable suspicion, suppression, probable cause suppression, and then a jurisdictional motions hearing.
I appear, especially, not generally. My presence is under duress, coercion, and threat of arrest if I fail to appear. This is not a voluntary submission to jurisdiction. I reserve all rights. I make no waivers, and I demand the court prove jurisdiction on the record before proceeding any further. You came in here and said the court is the people versus Ryan Chavez. The state and the people are a fictional entity. They cannot be cross-examined. They cannot testify. They cannot take an oath. So I demand that a living man or woman take the stand and that an injured party is presented. Otherwise, this case needs to be dismissed with prejudice.
Do the people intend to call a witness this morning?
I was going to call the officer who pulled him over on the day of the offense.
Is the officer the injured party?
An injured party is not required, Mr. Chavez.
It absolutely is required under Terry versus Ohio and Delaware versus Prowse. It requires articulate suspicion of a crime. Muddy plate is not probable cause, and obstruction further needs to meet Colorado Revised Statute 18.1041A requires physical interference, and Courier's own affidavit admits no act of obstruction ever occurred.
Your argument is noted. It's rejected by the court.
It's not an
I'm
argument.
denying
it's a
that
fact
argument.
of statutory.
You're making a record right now, and I'm denying any assertion that you're making that an injured party, a specific injured party, is required in this case. This is a statutory violation. The legislature of the state of Colorado has passed.
Constitutional protections and rights.
Okay, your record has been made.
It's a statutory fact under Colorado's own statutory law, and I will provide that to you. 3812-1409. Colorado codifies federal law shall govern and supersede conflicting state provisions. Colorado statutes do not supersede or override constitutional rights, protections, or federal law.
Okay.
So
How does that impact these
So for the
proceedings?
record and on the record, you are denying the supremacy clause.
What federal law are you invoking here?
The supremacy clause. You are bound to stand within the supremacy clause.
I'm asking you, Mr. Chavez, how does that impact these proceedings?
Well, until you prove jurisdiction, present an injured party, this case needs to be dismissed with prejudice.
That's what we're here to do today.
Well, you still need to prove jurisdiction before we proceed any further.
You're exercising your right to due process right now by invoking by filing motions and invoking a hearing on those motions. And that's what we're carrying out today. I will hear testimony and argument from the prosecution as well as you, and I will make a ruling on jurisdiction and on the veracity of the stop, whether there was reasonable suspicion and probable cause. Okay. You are exercising your due process right now. Whether it's state due process, federal due process, that is the proceeding we're carrying out now.
Correct.
Okay, so none of your rights are being violated.
Not yet. They have already been violated by Courier's stop.
Well, that's what we're here. That's what we're here today to determine. Okay, you need to let these proceedings go forward.
Well, you need to prove jurisdiction before we can proceed any further. You can't just jump and go to one thing to the next thing.
This court has jurisdiction over this proceeding.
And what proof are you going to provide me with?
We're going to hear testimony so I can determine whether or not I have personal jurisdiction over you based on the officer's testimony.
That's not how it works.
Yes, it is.
No, it's not.
Okay, we're going to go forward with these proceedings. If you want to appeal after we're done with these proceedings, you are welcome to. Okay.
Well, I reserve my rights under Title 42, 1983.
They are reserved.
1883, or excuse me, Title 18, 241, 242. Because at this point, you are in direct violation of my rights without proving jurisdiction.
What statute is that?
I just provided them to you. Those are United States codes, which again are
You're citing federal codes.
It doesn't.
Speak with Officer Jennifer Cruzy of Blue River Police Department about Mr. Chavez.
I did.
And what did she have to say about him?
Well, when I was back in my vehicle reviewing his history in Summit County for traffic stops, I found that he had been stopped twice prior, in approximately the last year by Officer Cruzy. One time was for speeding. The other time was for obstructed license plate and I believe registration. She told me that he was uncooperative with her as well, refused to provide driver's license, registration, insurance. She ultimately ended up letting him go with warnings both times. She told me that she was, after a lot of talking with him, able to convince him to provide her with she called it a sovereign citizen ID. I don't know what that is necessarily, but she said he provided that.
Okay. What's the objection?
That's prejudicial. You cannot use that term. I demand it be stricken.
What term?
Sovereign citizen.
We are not in front of a jury.
It's defamation.
There's no
Without
prejudice.
Proof you cannot use it against me. I'm not a domestic terrorist.
I'm not striking that. Your objection's overruled.
Okay,
There's nothing.
Show that this court is refusing to abide by federal law. It is condemned by federal law.
You may begin your cross-examination.
I invoke the hostile witness.
Excuse me?
I invoke hostile witness. They need to ask her leading questions.
You're allowed to ask your leading questions on cross.
Would you consider yourself an expert?
Yes, I've been sworn in as an expert in traffic.
Okay, and in your own affidavit, you admitted, and even to me, that during the stop that you don't know every Colorado revised statute. Is that correct?
Yes,
Okay, so it's safe to say that you're not an expert.
depends on your definition of an expert.
Well, you just said you were an expert, but you just also in your sworn affidavit said you don't know every Colorado statute.
Correct. I don't need to know every single statute, but if your definition of an expert is to know every statute, then no, I would not be. So
Well, the definition of an expert is that you are profound in whatever your profession is. You are a deputy. You just claim to be an expert. However, in your sworn affidavit, you said you don't know every Colorado statute. That pretty backwards, is it not?
again, depends on your definition of an
It's
expert.
not my definition. It's the standard definition of an expert. You just said you were an expert. In your sworn affidavit, you said you don't know every Colorado statute. That would go against being an expert, which again would probably lead into that you're training people who don't know that either. Correct?
No,
And that's your opinion? Or is that a fact?
I'm a little confused about the question. Opinion or fact to what?
Was it your opinion that you're not an expert and that you don't need to know every Colorado statute, even though you just said you're an expert?
Can you rephrase the question so that way I can better understand it?
Well, you said you were an expert. You sworn that you don't know every Colorado revised statute.
Mm-hmm.
You are training people in the ways that you feel are correct. However, you just admitted you don't know every Colorado statute, but you also admitted that you're an expert.
Mhm.
Would that not be indecisive
To
in
be,
the fact that you're not an expert? You don't know Colorado law.
again, I'll take you back to the definition of an expert. So if your definition of an expert
It's not
is
my definition.
is somebody who knows every single law in CRS, then no, I am not an expert. But per the courts, I've been sworn in as an expert on traffic.
What evidence have you been provided with that from a third party testimony that I'm a domestic terrorist? Have you been provided any evidence of that?
Domestic terrorist, I never used that word.
Citizen. Do you know what sovereign citizen means?
I know the general colloquial term.
Do you know what's an oxymoron?
With the heaviest emphasis on the moron part.
I don't understand your question.
Do you know what an oxymoron is?
No.
Okay, I'll break it down as simple as I can for you. Two words that mean two different things. Sovereign means you're independent. Citizen means you are governed by somebody. You cannot use those words together. They are legally irrelevant. Okay? It's also defamation. And that's under Colorado law. Did you know that?
No.
So have you been provided any evidence that I am a sovereign citizen or a domestic terrorist?
Officer Jen Cruzy, who pulled you over for Blue River, advised me that you had provided her with what she called a sovereign citizen ID. I was not there for that. That is what she told me. That's officer to officer communication and information. That is the only information that I have, the only background that I have on you. I don't know you outside of that.
And so it's her word that a state issued, Department of State issued passport is what she considers a sovereign citizen document.
That is not how she described it, so you'd have to ask her.
That's what you just said. You just said that she was presented a sovereign citizen, what she considered a sovereign citizen ID. So doesn't that go against what you just said?
No, that's what she told me.
And what proof does she have?
You'd have to ask her.
So again, this is third party hearsay testimony with no factual evidence, correct?
No, this is what Officer Cruzy told me, so you'd have to ask
That's
her.
hearsay. Do you know what hearsay is?
It's officer to officer communication and
That doesn't
information.
matter.
It's in good faith. It does matter.
Objection, Your Honor. Clearly, it's the fellow officer rule and it's not hearsay for the purposes of this motion's hearing.
That's your dash cam, correct?
I believe so.
Okay. So again, for the record, this was, do you want me to leave this with her?
Let me make sure I'm looking at the same. You're welcome to leave it up there for now.
You need it?
I don't think so.
So for the record, I just presented, I believe it was Exhibit A. Forgive me.
It was.
Okay, thank you. Dash cam photo of Deputy Courier's, of my truck from Deputy Courier's cruiser on, I believe it's 614. Did you make any attempt to clear my license plate?
I did. I went behind and I wiped some of the dust off, but I was still unable to see underneath it.
Okay, and so you just testified that it was a smoke-covered license plate. And now you just said that you attempted to wipe dust or mud off of it, correct?
Yes.
Okay, now in that photo, there's, given the very poor, in my opinion, quality for 2025 when phones have 8K capabilities, why your dash cam doesn't have that type of capability is unbeknownst to me. But clearly, that truck is covered in mud. Are you familiar with the term mud season in this county?
Your Honor, I would object to this line of questioning as it's irrelevant. The applicable statute 42-3202-2B just says that a person shall not operate a motor vehicle with an affixed device or substance that causes all or a portion of the license plate to be unreadable by a system used to automatically identify a motor vehicle. Such a device includes, without limitation, a cover that distorts angular visibility, alters the color of the plate, or is smoked, tinted, scratched, or dirty so as to impair the legibility of the license plate. Whether it's mud, dirt, or dust, it all qualifies under the same statute, so I don't believe that this line of questioning is relevant at all.
In that same statute, it does clarify that mud during specific times of the year, just like winter when your car is covered in snow, it just advises that at the quickest time to clear it when possible.
Well, Mr. Martinez, you're right. That is the statute that's applicable here. I do think that this questioning is still relevant. So I'm going to allow Mr. Chavez to explore this a little bit more, but once the point's been made, I'll ask him to move on. So that objection's overruled. Go ahead, Mr. Chavez.
Thank you. Other than what you testified as my demeanor,
Oh, thanks.
in any other way did I obstruct you physically from doing your job?
Physically? No.
Okay. Are you aware that under Colorado Revised Statute 18-8104 and Colorado law requires physical interference, and that even in your own affidavit, you clearly said none of that existed?
By not providing me with driver's license registration or insurance, that is interference.
Under Colorado law, it's not, because you never